again, this is another one of those questions that's going to be very state specific. The state law will dictate the execution requirements for these forms, but most time it is going to require witnesses, and those witnesses need to be disinterested witnesses. So what that means is it's not someone that you have named in the document.
Okay.
So if you've named your spouse cannot serve as a witness. Second, they may also request that the forms be notarized. There are some states that don't require that. For example, in Georgia, your medical power of attorney does not need to be notarized. But there are some states like Florida that will require that you have those two disinterested witnesses and a notary.
So I guess when all else fails, if your state doesn't require a notary, there's no harm in getting it notarized,
Correct.
though. Okay.
Correct. Yes, it doesn't hurt it. It'll won't help it, but it doesn't hurt it.
Okay. Got it. So the first question was, do your forms need to be notarized? Thank you for sharing that.
All righty. Giovanna said, if my dad resides in Maryland 3/4 time, in North Carolina 1/4 time, and owns property in both states, should I have him get estate documents sent in place in both states? So they're like by...
Yeah. So the question is, if you happen to reside part-time in one state and part-time in another state, which state's forms should you be signing, basically? And I'm going to call on an accounting here because I know we've got an accountant here. This is usually a residency requirement. So most states are going to require that you are a resident of that state for 165 days or more of the year. And that's usually where you are intent to reside and plan to continue to reside. So that should be the state's forms that you're signing, the state in which you are a quote-unquote resident of.
So wherever you're filing for tax purposes, the state that you're claiming, that's where your estate document should be drafted. Great question.
Very good question.
Yeah, we have some good other ones as well. Donna K said, what do you do if you don't want the beneficiary to be a blood relative?
Oh, that's perfectly fine. The question is, what do you do if you don't want the beneficiary of your documents to be a blood relative? As I was stating before, I can draft anything as long as it's legal. So if you want all of your assets to go to your friend Jane Doe instead of to your parents or to your siblings, that is perfectly fine. You do not have to leave your assets to your family members. We even have clients who have children that say, you know what? I worked hard for my money. I don't want them to get a dime.
Yep.
I want all my money to go to charity. They're going to have to figure it out. They're going to have to work for their money. So I want nothing to go to my kids. So you absolutely can dictate who it is you want to receive your assets in your document.
I was talking to a friend just about 2 weeks ago who does not have children, and she attended Howard, and she said, you know, when I work on my documents, she said, if my mother has passed away, I want everything I have to go to Howard. Mm-hmm. And I said, you know, I appreciate that, but I'm like, you realize it's not going to happen if you don't have a will.
Yeah.
It's never going to happen.
Right.
So it's your money. You earned it. You can give it to whomever you want.
Yes, we have a few more questions. V. James asks, can you add your stocks to your will?
Oh, absolutely. So when we are drafting wills and trusts, usually the first step when you see an attorney or you see someone like me is we're going to ask, what are all of the assets that you own? So do you own a home? Do you own other real estate? Do you own stocks and bonds? Do you own valuable tangible property, like things you can touch? Do you have artwork? Do you have jewelry? Do you have furs? Do you have cars? All of those things. And when we are drafting your document, we are drafting your documents with the intention of distributing all of those assets. Now, it's not that we have to put them all in one bucket and distribute them all to one person. You can say, you know what, I want my jewelry, my furs to go to my daughter, and I want my cars and my guns to go to my son. So it's absolutely how you want to draft it, but we are taking into account all of the assets that you own in your name. So when you talk about the probate process, what a court would be looking at would be what assets are titled in your name at the time of your death. That's what they're looking at through a probate process, and that's what we are drafting around.
Okay.
Tanisha Riley asks, please explain the type of trust and who can be a trustee. i.e. business.
Okay. So can you just define, because we're using these terms and I just don't want to take for granted that people know what they mean.
Absolutely.
So just quickly, what does will?
Yes.
Define will.
Okay. A will is a document that administers your assets that are titled in your name at your death. So again, if you own a car, if you own a house, those are assets that are what we call probate assets, assets that can be dictated under a will. Now, a will, you are going to appoint someone called an executor or a personal representative. I equate that executor personal representative role, and the name is synonymous, it's the same thing, with almost like the cleanup crew. Okay. So who's coming in when you pass away and making sure that your neighbor doesn't come in and steal your money under the bed? Who is turning off your AT&T cell phone bill?
Yeah.
Who is making sure that we are corralling and bringing in all your assets to make sure that they are going to the right person? Mm-hmm. So that's really what a will handles. A will can also dictate guardianship. So who you want to be a guardian of your children, that is also something that goes under a will. Now, a trust is a different type of document. A trust is something that can be revocable or irrevocable. And that basically just means, can you change it or not? So can you amend it or can you not? And a trust is a much longer life cycle than a will. So a trust is something where you can dictate, like we said before, the timing and the manner of distribution of assets. So if you come to me and you say, hey, Tiffany, I've got a 5-year-old child. I want to make sure that they don't get assets until they're 30 or 35 or 40 or when they start a business or when they get married. Those are types of things that we would put in a trust. So as you can see, the trust could possibly last from when your child is 5 to when they're 35 or 60 or 70. So it's something that's much, much longer than just the cleanup crew, which is the will. So the trustee is the person who administers the trust. Remember, the personal representative / executor is the person who administers the will. A trustee is someone who administers the trust.
And so, excuse me, they don't have to be the same people.
They do not. They can be, but they do not.
They don't have to be. Okay.
And there are also companies, we call them corporate trustees or corporate executors, who can serve in that role as well. So if you've got assets and you say, you know what, I don't really trust anybody to do either one of these things, there are corporations and there are people that you can pay to do it as well.
Interesting.
Yeah.
Okay. And for those of you who are curious about that, like when David and I updated our documents, it was because we hadn't done it since our children had become adults.
Right.
So that was a new life event.
Yeah.
I know we got our documents done initially when my mother passed away suddenly. We were like, wait. What are we going to do? What's going to happen with our kids if something happens to us?
Right.
So life events, a lot of times I've seen people have to update their documents.
Yeah. I would say that one of the biggest reasons that I see why people update their documents is changing the people that they put in charge. So, for example, that personal representative or the executor or the trustee or the guardian, I get the call and I'm like, the person's like, I'm not really rocking with them anymore. I don't want to put them in my document. So that's what we see more often than not, is changing those agents that you've named because of obviously life events. You fall out with people. Maybe they're not as trustworthy as you thought they were. So that's a big reason to change.
I know my husband is going to talk about me for saying this, but when we updated our documents with you, that was our 3rd time. But the 2nd time when we looked, we were like, how did we pick those people? What happened? What were we thinking? Because everything was so different.
Right.
Everything was so different. At the time, it was the right decision. But as life had progressed and our children, grown up, we were like, no, we gotta switch this around here.
Yeah.
You had 2 more questions, and ladies, then we're going to get into these forms.
All right. V. James asks, I was told I need to add all of my passwords on my will. Is that true?
The question is whether or not you need to add your passwords to your will. And the answer to that is no. You do not need to add your passwords to your will. Passwords is an interesting topic and something that I talk about a lot. I talk about digital estate planning quite a bit. I have a whole presentation on it. Next time I do it, I'll make sure that you get a link so you guys can join.
Yes, please.
But it's interesting now because so much of many people's lives are conducted electronically. Their businesses are conducted electronically. So, and we've even gotten to a point where there are assets, as we call them, digital assets, like cryptocurrency.
Right.
You know, that's not something that we used to plan for.
Right.
NFTs are a
Right.
big thing now,
Right.
something that you wouldn't plan for. You've got people making millions of dollars with an Instagram handle,
Right.
millions of dollars with a YouTube handle.
Right.
How do you actually pass those assets on? It's not like just giving someone a ring,
Right.
or giving someone a car. I can't just give you that.
Right.
You need the password. You need the login credentials. You might need the other like image credential. There's a lot of things that go around those digital assets. And normally what I tell clients is to work with a couple different things. One, you can jot your passwords down. The difficulty with that is you are often changing
them. Right.
So it's hard to remember where it is you jotted it down last time, update it in time, remember it, and then telling your family members where that piece of paper is, that gets a little bit more difficult. So I often recommend password software and password keepers. Like I think one is called
Ani, which one do you use? Ani uses Dashlane.
Dashlane.
Okay.
I know there's Zoho, there's Passkeeper, I believe it's called. There are a lot of websites and software that can help you with that. And I recommend putting those passwords and those credentials on those types of platforms. And then in your will, mentioning what the digital asset may be. So let's say, like we had the example of an Instagram handle. So putting in your will, I have a very valuable Instagram handle. This is what it is. The passwords could be on my password keeper. So that you might put in a will, but not the actual passwords itself, because one, the passwords change all the time.
Right.
And two, another big thing that we didn't discuss that I'll bring up now is that wills are of public record. So when you pass away, your will has to be filed with the clerk in the county in which you reside. So we try very, very hard not to put confidential information in a will.
Good to know, ladies. I did not know that.
So if you want to go pull up Whitney Houston's will right now,
Right.
you can. It
Wow.
is public record.
Wow.
So
What? Ani's over there raising her hand in the background. What's your question, Ani?
So when you're changing, because at first some people just do it on LegalZoom.
Yeah.
And they don't go file it at the court. Does that not make it valid if it's not filed?
So the question is, if you're making edits to your will on a LegalZoom or any other internet platform, what do you do then, because it needs to be filed with the court? A clarification there is it is filed with the court at the time of your death,
Yes.
not while you're
Before.
alive.
Right.
Because remember, again, wills can be changed at any point.
Right.
Right.
Okay.
So it's only filed when you die. Any questions on background before we go into the document itself?
Yeah, we do have a few questions. Tanisha Riley asks, do we give this to our primary care physician or hospital?
Most often a doctor will ask for it if you're going into the hospital. So if you've ever had a surgery, I'm sure they've asked you, have you filled out a medical power of attorney or an advance directive?
Yep.
And if you haven't, they will give you one to fill out. So I just had surgery. I broke my foot. I was telling these ladies this earlier this year, and I went in there with my documents. I'm ready to go. Here you go.
Right.
Mm-hmm. And then Adrian asks, in the healthcare power of attorney document, it has client name that cannot be removed. Is that okay?
Client name. Which document?
What state
Yeah.
are you, Adrian? That would be helpful to know. Georgia.
Georgia.
Huh.
That should. We're about to go through the Georgia one. I'm not sure where we have client name.
You may have to like.
Oh, I know where it is. It's right here on the top. It should be able to be removed. It's a Word document.
Yeah, if you
Okay.
may have to use like Microsoft Word or Google
Yeah.
Forms. I mean Google Docs.
Because, your name goes there.
Correct.
Correct.
Okay.
Okay.
So good question, Adrian. If we want to go right into it, we
Okay.
could.
Let's start preparing.